అంటే దీని మరి మత మతం లేని లౌకిక దేశంగా భారతదేశం నిర్ణయించుకుని లౌకిక దేశంగా ముందుకు పోతున్నప్పుడు మరి న్యాయవాదుల్లోను న్యాయమూర్తుల్లోను కూడా ఏంటంటే న్యాయమూర్తుల నియామకంలో మతాన్నే ప్రాతిపదికగా తీసుకునేటువంటి ఈ కేంద్ర ప్రభుత్వం బయలుదేరింది అనేటువంటిది మనకు అర్థమవుతా ఉన్నది. మైనారిటీలు కానివ్వండి, అంటే క్రైస్తవులు కానివ్వండి, ముస్లింలు కానీ న్యాయమూర్తులుగా వాళ్ళ పేర్లు వెళితే వాళ్ళని సాధ్యమైనంత వరకు రికమెండ్ చేయకుండా ఉండటానికి, రికమెండ్ చేసినా కానీ చాలా సంవత్సరాల తర్వాత చేసినట్లయితే వాళ్ళ సీనియారిటీ కోల్పోయి వాళ్ళు కొలీజియంలోకి రాలేని పరిస్థితిని కూడా తీసుకొచ్చేటువంటి పరిస్థితి మనం గమనిస్తా ఉన్నాం. మరి న్యాయ వ్యవస్థని న్యాయమూర్తులు రాజ్యాంగాన్ని కాకుండా లౌకిక తత్వాన్ని కాకుండా రాజ్యాంగ సూత్రాలని కాకుండా మరి మనుధర్మ శాస్త్రాన్ని మెజారిటీ హిందూయిజాన్ని గనక పాటించేట్లయితే ఈ దేశం ఏమవుతుంది అనేటువంటిది కూడా మనం గమనించాలి. అందుకని న్యాయవాద వ్యవస్థ కూడా మనం అనేక సమస్యలు న్యాయవాదులు ఎదుర్కొనేటువంటి అనేక సమస్యల మీద పోరాటం చేస్తూనే న్యాయ వ్యవస్థ యొక్క సర్వ స్వతంత్రాన్ని బలపరుస్తూ దాన్ని నిలబడటానికి రాజ్యాంగబద్ధంగా అది పనిచేయటానికి అవసరమైనటువంటి చర్యల కోసం మనం పోరాటం చెయ్యందే ఈ రోజున భారతదేశంలో ప్రజాస్వామ్య మనుగడకి లౌకిక తత్వ మనుగడకి ముప్పు ఏర్పడేటువంటి పరిస్థితిని కూడా మనం గమనిస్తా ఉన్నాం. అందుకని ఈ కాలంలో రాను ఏంటంటే న్యాయ వ్యవస్థ మీద కూడా దాడులు ప్రారంభమవుతాయి, ఇప్పటికీ అయినాయి, జరుగుతాయి. అదేవిధంగా న్యాయవాద వ్యవస్థ కూడా మనం మరింత బలంగా ఉండి సంఘటితంగా ఉండి మన స్వతంత్రాన్ని కాపాడుకుంటూ న్యాయ వ్యవస్థ స్వతంత్రాన్ని కూడా కాపాడే దాంట్లో మన బాధ్యతల్ని మనం నిర్వర్తించాలని, మనం అనేక న్యాయవాదులు ఎదుర్కొనేటువంటి ఇతర సమస్యలతో పాటు కూడా దేశం ఎదుర్కొనేటువంటి న్యాయ వ్యవస్థ ఎదుర్కొనేటువంటి సమస్యలపై పోరాడాల్సిన బాధ్యత ఉన్నదని, ఆ విధంగా ఈ ఆవిర్భావ దినోత్సవం రోజున మనం పునరంకితం కావాల్సినటువంటి అవసరం ఉన్నదని చెప్తూ ఇప్పటికే మన ఆల్ ఇండియా ప్రెసిడెంట్, అదేవిధంగా ఆల్ ఇండియా జనరల్ సెక్రటరీ కూడా ఈ సమావేశానికి అటెండ్ అయ్యారు. కాబట్టి మీ అందరికీ ధన్యవాదాలు చెప్తూ మనం ఈ సమావేశాన్ని కొనసాగిద్దాం. థ్యాంక్ యూ టు ఆల్.
Dear friends, good evening to all of you. This session is being organized on the eve of 42nd Establishment Day of All India Lawyers Union, Celebrations Day. All India Lawyers Union striving for the cause of upholding the constitutional principles, whereas the AILU having an independent constitution in consonance with the Constitution of India to protect the democracy, secularism, which are the cherished values of our great constitution, Indian constitution. So AILU for this long period, 42 years of long period, achieved a lot by conducting various type of programs, including seminars, discussions, roundtables, conferences, and various deliberations for the purpose of establishing and rightly implementing the rule of law, democracy, and the cherished values of socialism and secularism. So in this particular eve of this day, we thought of All India Lawyers Union, Andhra Pradesh State Committee thought of to conduct this type of Zoom session by inviting our national leaders, Sri P.V. Surendranath, General Secretary, All India Lawyers Union, and eventually the Senior Advocate, Supreme Court of India, and also Sri Vikas Ranjan Bhattacharya, Honorable MP, Rajya Sabha, and the Senior Designated Advocate, and also our National President of All India Lawyers Union. On this occasion, without taking much time, I invite Sri P.V. Surendranath, General Secretary, All India Lawyers Surendranath. Hello.
Hello.
Sir, please.
No, you first invite Bikasji. He's the president. That is propriety. Please invite Bikasji first.
Okay.
Invite
Okay.
Bikas. Yeah.
Hello. I invite Sri Vikas Ranjan Bhattacharya, President, All India Lawyers Union, National President, MP Rajya Sabha. Please, sir. Vikas.
Thank you, but I didn't expect this from my secretary that he will not take the responsibility of opening this deliberation. It was his.
Actually, the thing is.
Anyway, the issue is today. I am thankful. I am thankful and grateful to my Andhra Pradesh state unit that they have reminded us that today is the foundation day of All India Lawyers Union. And then we should recollect and remember those days when there was a decision to form this All India Lawyers Union. The question is, what was the immediate necessity of formation of an organization like All India Lawyers Union when there were admittedly some other organizations of different name? I'm not going to name them, but there are many organizations. Still then, why was it the idea of the democratic secular polity of the country to form an independent organization like All India Lawyers Union? At that material point of time, I must say that we were very young. We just had entered into profession, had just 4 or 5 years in our profession in 1983. When there was a convention, which was at the initiative of late Hardev Singh, who was the first founder secretary of the organization, and many other lawyers, mainly from Delhi High Court. And we did get ourselves involved in the formation of the organization, and that was inaugurated by all the celebrated personalities in the world of politics, democratic politics, and the Constitution of India. I still remember as a young man, I was really, I had awe. I was wondered to see that personalities like Justice Krishna Iyer, Justice Alok Gupta, Justice H.R. Khanna, political personalities like Jyoti Basu, EMS Namboodiripad, all these great personalities, they got assembled together. And they had expressed that the time has come when the country needs an organization of the lawyers, particularly. How come the organization of the lawyers come into their mind when there are so many organizations? And amongst the lawyers, there was a lot of confusion, which I had faced, I had to encounter, I had to also discuss with this, that we have Bar Council, we have Bar Association, there are other lawyers organizations. Why should there be another organization like All India Lawyers Union? This was a terrible discussion amongst the informed lawyers who thought that the Bar Council, Bar Associations, they're good enough to take care of the interest of the lawyers. But the question came, would the Bar Council or the Bar Associations and the other lawyers organizations who were then in operation be able to think of the social problems, the constitutional problems relating to the basic needs of the human rights? Would they be able to address that? I still remember that while participating in the discussion, as the inaugural discussion, that was a convention, then the organization was not yet formed. There's a convention at the mass level. Justice Krishna had addressed, Mr. Jyoti Basu was one of the very prominent political figure in the country. He had addressed, EMS Namboodiripad, they told us that, see, we have noticed that the Constitution of India, if it is made to be workable, then the function of the independent lawyers, independent in the sense that who can really implement the percepts of the Constitution, the modes of the Constitution, ethos of the Constitution, they have to be united. Now, while the deliberation, the reference was made, but this was just, you see, consider the 75 was the day of declaration of emergency. 77 there was election, and then in the election an alternative government came into being, and that government was functioning. Still, the very conscientious and left political personalities thought that the danger itself is hidden in the constitution. The emergency declared by Mrs. Indira Gandhi in 1975 was in exercise of the constitutional powers. And she was guided by a very eminent lawyer, then again from Bengal, Mr. Siddhartha Shankar Rai. I had the privilege of having his companion as appearing against him, and ultimately he became very affectionate to me. That's a different, the personal things. But they had advised that in a particular situation, the constitutional powers can be invoked to declare internal emergency. And declaration of internal emergency means the suspension of all democratic rights. And as you know, very well known, I can't say celebrated judgment, but a well known judgment of ADM Jabalpur versus the other one, where the Supreme Court had said, majority except Justice Khanna, they have said that during the emergency, all of your fundamental rights are suspended. Therefore, you cannot even approach the constitutional courts like the courts under Article 226 or Article 32 for enforcement of fundamental rights. And that created a huge uproar. Therefore, the political community, led by the basically rational and leftist leaders, they thought that the constitution can best be interpreted and can best be implemented by the lawyers. They're the best person who can judge and who can analyze the different provisions of the constitution and implement. And that implementation must be towards the implementation of the ethos and the philosophy of the constitution. That's why after 1983, the convention, a body was formed, and a great personality like Mrs. Daniel Latifi, he was a well-known counsel and a well-known personality in the field of law and democratic movement. He was chosen as the first president, and Mr. Hardev Singh, he was chosen as the secretary of the organization. We were then minions. We were in different forms, in different organizations, structural level, executive committee, so and so. Those are not very material. But then a new era in the lawyers' movement had practically stepped into the field of the implementation of the constitutional ethos. We had decided with definite aim that the constitution speaks of egalitarian society. When you think of an egalitarian society, then how could the egalitarian society be conceived of? It is conceived of because of the basic tenets of our constitution, which is reflected in the preamble of the constitution. I still remember that Justice Krishna, whenever he had the occasion to address us, he used to say, read the preamble once, read the preamble twice, read the preamble thrice, and go on reading the preamble 100 times. Then you will appreciate what is the Constitution of India is. The preamble of the Constitution of India, which is the, if I may use that expression, I can't say I have the audacity to take cue from Justice Krishna here, but on my own appreciation, I could say preamble is the heart of the Indian Constitution, Indian society, Indian democracy, Indian polity. And this Constitution was achieved out of a great lot of sacrifice and struggle against the British imperialism. We fought out the British imperialism. Ultimately, we have won this political independence, as Mr. Ambedkar said, that we have won the political justice, but we have yet to earn, or you have to secure the economic and social justice. Dr. Ambedkar made us aware by his caution that yes, today we are entering into a new era. 15th August of 1947 with the transfer of power. Now the power is transferred to the Indians from the hands of the Britishers. But this power, how would it be utilized? And this power should be utilized for the purpose of securing social and economic justice. The preamble says of three justice: political, social, and economic. Ambedkar said, yes, we have gained the political justice, means that each one has one right of vote having equal power, equal value. Therefore, the vote casted by, I always speak of the, say, maybe Tata and Birla will have the same value that of the vote casted by Riksha Pula. But again, is that the reality? Ambedkar cautioned. Ambedkar had the great vision, and he had cautioned us. You see, this would not really be a political justice unless we can ensure economic justice. There will be no political justice. How it comes to a person, a poor person, suppose a rickshaw puller or a mutia, he has to depend his livelihood, his livings, his shelter, his son's education at the mercy of rich people, moneyed people. Can he exercise his independent right of voting? Therefore, if he cannot exercise his independent right of voting, then saying of these holy words that equal value of one vote would be absolutely nugatory. And that's why the Ambedkar said, unless we can ensure economic justice, then our democracy would be at peril. He was so right, if I may use that, he was a soothsayer. He could visualize that in case we do not ensure economic justice, the political justice would be a farce. And unless you can secure economic justice, social justice would be just an illusion. But how could this economic and political justice be achieved? The more fundamental principle as our constitution, as it is provided in the preamble, is freedom of thought and freedom of expression. Then how can you secure freedom of expression, freedom of thought, unless you have freedom of education? Unless you know, are you aware of the whole situation of the country in all aspects? I am not detailing out. You cannot have your independent choice of voting. There were these cautions which were given by the creators of the Constitution now has become absolutely true in our life. When the emergency power was exercised by Srimati Indira Gandhi, taking resort of constitutional power, then it was also ringing a bell. Therefore, this constitution empowers you to become an autocrat. Then the leader said in the meeting that if that is the constitution has other positive sides, why would not the lawyers who can speak better on the constitution get themselves organized? And an organized force is much more impactful than the individual force. And individually, someone might be brilliant. Individually, someone might be extraordinary, but that would not achieve result unless it have a organizational force which has a greater impact. That's why the All India Lawyers Union was formed with the specific target and objective that the duty of the All India Lawyers would be to preach, perceive, conceive, and implement the ethos of Constitution. I very often say in different forums that the ethos of Constitution and the constitutional morality is the basic concept of upholding the dignity of the Constitution. And the constitutional morality, again, depends on your independent right to think and to respect the dignity of individual. This is very, very important. Because we live in a society, we live in the midst of a culture where we have been taught, we have been brought up with the idea that someone is untouchable. If they even touch my drinking water, then I can kill him. That's my right. If he or she belongs to a down-to-earth community or Shudras, then I have every right to exploit him. These are the philosophy which has been preached in our country through years, and ultimately leading us to a country of obsolete ideas. Here, we may call Swami Vivekananda and all others. Everybody had faced this, and Swami Vivekananda had said in his elocution in the Chicago conference, which is very important in the present context. He said that I come from a country, I come from a religion which has given shelter to all the oppressed, all the tortured, all the perpetrated of the world, and that's the biggest asset of our country. What's happening today? And that idea of Swami Vivekananda, or say Tagore's idea, where the held is high, mind is without fear. If your mind is without fear, if your head is held high, and that all depends on the knowledge. The knowledge will give you the perspective of keeping your head high and mind is without fear. Without that, you cannot have the concept of democracy. Democracy means, as it was said by a great Western philosopher, that I may differ with your views, but I still try to protect your views, even in case I have to offer my life. That's the foundation of democracy. Democracy means the protection of the different voice. Your voice may be right, but his voice, though it may be wrong, it has to be heard. And that was reflected in our constitution when you say freedom of thought and expression and dignity of person, freedom of religion, freedom of faith. Every individual has that right, and it's duty of the state, which is a democratic republic state, is to protect that. In course of time, we have seen, unfortunately, these values of the constitutions have been thrown aside. Now the slogans are raised. Even I'm very unfortunate, I'm very pained to say, I can't say unfortunate, I'm very pained to say I have noticed in the address of the President of India, in the last budget speech, he had said that we are one country, we have a one ideology, we have a one philosophy, we have one leader. What nonsense. India is basically a multicultural, multinational country. We have joined together in our fight against the British imperialism, the fight against the capitalism. That was the source of unity. And that's the foundation of basic historical events in our country. But now it is being tried. They have been trying to push this idea. This is one country. This is one language, one culture, one leader. This so-called oneness is the reflection of fascist ideology and fascist culture, which does not go with our plural culture and plurality, which is reflected in the Constitution. When the Constitution says we are the union of states, not a unity of states. There's a gulf of difference philosophically and legally, the concept of a union of states and unity of states. Now, this government in power, they want to impose upon us the concept of unity of states, not the union of states. These are all against the basic concepts of the Constitution. Who can fight it out? We, the members of the All India Lawyers Union. That was the concept which was deliberated by, I still remember, EMS Namodripad, Jyoti Basu, and particularly Justice Krishna Iyer. He had repeatedly said that we belong to a country which has bloomed with many flowers of many colors. We have to protect that. And thus the All India Lawyers Union was established, founded. We have been proceeding gradually. We have yet to reach all the lawyers, yet we are holding a very minimal faction, but still our attempt to reach all the lawyers and to make them convinced about the basic philosophy of the Constitution, basic ethos of the Constitution is our obligation. We have not yet been able to fulfill that. Far away from fulfilling, we have not been able to carry forward this message to the larger section of the lawyers and the social community that the plurality is the foundation of our national unity. Unity in diversity and diversity in unity. That is the basic concept of federalism, which has been missing. These are big issues which you have to discuss time to time whenever a situation arises. But today, when we are remembering the Foundation Day, I'm very happy to say, I'm very glad to say that our units throughout the country have been trying to carry forward, have been trying to make people convinced about the basic ethos of Constitution. I know we have to face a lot of difficulty, a lot of hurdles. It's not an easy task, but difficult task makes us much more confident that we can definitely find out the solution with our determination of organization. And our organization should go on approaching the lawyers community more and more to bring them within the encompass of the constitutional morality and constitutional ethos, which is the basic foundation of our organization, and make them people feel that whenever your democratic right, human rights are under attack, if no one is there, you can very well find All India Lawyers Union. They will stand by you and they have to fight for you. I conclude giving two examples, the examples of state of West Bengal and the Tripura. Just 2 days before, I had been in Tripura, where I found it's a horrible situation. The devastating attack on the people who had expressed their opinion against the BJP, RSS. The RSS had initiated the idea of division of country in the name of two-nation theory, along with the Muslim League. That RSS is still trying to impose the concept of Hindu Rashtra, one nation, one culture, one man, one philosophy. This idiotic concept they try to push forward. And if you do not accept, they will force you to accept to that and bow down to them. This barbaric fascist attack on the common man is a very dangerous signal. And we, the lawyers, we have to rise to the occasion to face it, and face it very confidently within the framework of the Constitution, with the idea of fulfilling the constitutional goal. There, the significance of All India Lawyers Union. I conclude by saying we should stand by that, and we will definitely push forward the idea of All India Lawyers Union means the basic concept of the Indian Constitution. With these few words, I thank you all. I'm grateful to my friends from Andhra who had organized this seminar to commemorate the foundation of All India Lawyers Union. I feel proud to be a part of you. Thank you.
Thank you very much, sir, Vikasji, for your speech, organized speech on this auspicious occasion. Now I invite Sri P.V. Surendranath, General Secretary, All India Lawyers Union National Committee and Senior Advocate, Supreme Court of India, to please give his message.
Dear friends, my dear friends, Nara Srinivas, Rajendra Prasad, our great President Bikasji, dear friends. Let me at the outset express my gratitude because on a short notice for a call from the center, AILU Center, the Andhra Pradesh Committee programmed this Zoom program, that is online program, to commemorate our Foundation Day. The circumstances, am I audible, Nara? Nara?
Yes, sir, completely audible. Yes, sir, we are hearing.
The circumstances at which the All India Lawyers Union was formed in 1982 have been stated effectively in detail by our President Bikasji. So, to justify our existence for the last 42 years, our journey, the constitutional journey of All India Lawyers Union during these 42 years, let me nutshell put 2-3 things. Let us remind one thing, that till the proclamation of emergency, the rift between the judiciary and the executive was basically on the interpretation of the Constitution vis-a-vis Part 4, Directive Principles of State Policy, against Part 3 of the Fundamental Rights. Whenever the Parliament passed or state legislatures passed some sort of land reform legislations, they were set aside as unconstitutional by the Supreme Court. So historically speaking, there was tug of war between the Parliament, legislature, and the judiciary, the Supreme Court, basically Supreme Court during those times. And whenever Supreme Court set aside such a legislation, such land reform legislations, our Parliament overruled those judgments, in the sense they removed the substratum of that judgment by amending the Constitution, amending the enactments. So generally, the right-thinking people of India, including we lawyers, were supportive of such legislations, and necessarily, for that matter, amendment to the Constitution as well. But the emergency was a jolt to this situation, because during emergency, we realized that using the very same Constitution, using the very same democratic forum, India can lead to a totally authoritarian, fascistic regime. Because if you get majority in the election, and when there is so brute majority in the election, you can amend the Constitution. And in that situation, you can even change the Constitution, that Constitution, Republican Constitution, to a presidential Constitution, whatever manner. And there we realize that if there is no independent, accountable judiciary, if the judiciary is committed to the regime in office and not to the Constitution, definitely it is the peril of our democracy and the Constitution. So we stress the requirement, the basic requirement of our democracy is that there should be an independent, accountable judiciary. But at that time, the regime was speaking about committed judiciary. Doesn't mean that committed judiciary concept is committed to the Constitution. It should be so. But in the phraseology of the then regime, the committed judiciary means committed to the regime in office. So we brought this concept of independent judiciary and said that an independent, accountable judiciary in India means it has got directly linked to how you elect or select our judges of the constitutional courts, especially in the light of the fact that despite our clear understanding of Article 21, despite Article 32 and Article 26 of the Constitution of India, as Bigas rightly pointed out, in ADM Jabalpur, Supreme Court clearly declared whatever be the violation of right to life, whatever be the illegality committed by a police officer or a military person, security person, shooting an innocent person on the road, on the street, you have no remedy, you have no constitutional remedy at all. You can't challenge that in a constitutional court invoking Article 32 and 226 of the Constitution. This is the alpha and omega of ADM Jabalpur. So this is directly linked with independence of the judiciary. How far you are capitulating before the executive dominance. That's why we projected the idea, we brought the idea of selection of judges of the Constitutional Court to the public domain. That is why we projected the idea of National Judicial Commission. An independent National Judicial Commission should be there for selection of judges of the High Courts and Supreme Court. And we campaigned for that. And at that point of time, no other organizations, no intellectuals supported that idea. Still, we campaigned for that. Our great General Secretary, founder General Secretary, Hardev Singh campaigned for that. And after some time, it started capturing the imagination of right-thinking people in India. And now, the majority of the right-thinking people of India realize that there is a requirement of an independent alternate mechanism for selection of judges of the High Courts and Supreme Court. Then question may ask, why did you support the collegium in those days? The answer is, there is nothing absolute or abstract principle in constitution interpretation or politics, because the collegium came into vogue because of executive dominance shown by the regime in office at that time. And that was reflected in ADM Jabalpur. So it was the requirement, it was badly needed in at that time that there should be an end of executive dominance in the selection of judges. To an extent, that was materialized in the collegium system, but it was the other extreme, that there was 200% dominance of the judiciary at that time. So we started campaigning against these vices of the collegium system, because it is absolutely opaque, non-transparent, and not accountable. So this is the context at which we campaign against the vices of collegium system in selection of judges of the High Courts and Supreme Courts. And this, when the pressure reached the threshold limit, the Parliament, though apologetically, introduced an act, that is Constitutional Amendment for introducing a new system of selection of judges, that is National Judicial Appointment Commission. That is not as per our vision. We don't want an executive dominance in that concept. But the regime, the BJP regime, brought even law minister in that selection process, and that was challenged before the Supreme Court, and that is the 4th judge's case. Supreme Court said that we don't concede, we can't concede executive interference in selection of judges that will impede the independence of the judiciary. So after that, even after that fourth judge's case, there has been ample scope for a fresh amendment, fresh look into the issue, and fresh amendment to the Constitution within the four corners suggested by the Honorable Supreme Court. They did not venture for that. The reason is they thought that it is better to keep this collegiate system for selection of appointment of judges of the High Court and Supreme Court, because using this system, they can push their candidate. The executive, especially the Sangha Parivar regime, could push their candidates by bargaining with this collegium. So they never venture for a new, fresh amendment to the Constitution to make a perfect, independent, autonomous constitutional body mechanism for selection of judges. And not only that, they went further. They now started campaigning for a totally sovereign, supreme, or supreme, what you call supreme legislative, that is supreme parliament, without conceding any power of judicial review to the Supreme Court or the High Courts. So this is the core issue. Supreme Court, interpreting our Constitution in Keshavananda Bharati, declared that the Constitution has got certain basic structural concept, and that cannot be amended by the Parliament, whatever be the majority. Parliament cannot amend the basic features, change the basic features, or the basic structure of the Constitution. The power of judicial review of the judiciary is part of basic structure of Constitution. Parliamentary democracy is part of basic structure of the Constitution. Secularism is part of basic structure of the Constitution. These concepts cannot be changed, amended by the Parliament, whatever be the majority. This is the first hurdle for this regime. They want to have a full-fledged Supreme Parliament without conceding any power to the judiciary to look into the constitutional validity of any law or even constitutional amendment. If the Parliament passes a bill with the majority, that is the end of it. You can't look into, you can't subject that enactment to judicial review to declare that this act or this constitutional amendment is unconstitutional. That is why our Vice President, our Law Minister, and our higher echelons of the present government is campaigning against the basic structure and the judicial review concept interpreted by the Constitution Court, that is Supreme Court. So that is why now the added responsibilities on the All India Lawyers Union, shoulders of All India Lawyers Union, to fight against this campaign by the executive itself. It is undertaken by the very executive, which is bound to protect the Constitution and the laws. Now, directly the executive, the political executive, is campaigning against the constitutional principles, against the judicial review concept, and against the basic structure concept. It has been campaigning against the concept of secularism, the constitutional concept of secularism. It is now campaigning something more. it started disinformation that Indian constitution is colonial, the parliamentary system of democracy is colonial, all the enactments are colonial. We have go back to Indian legal system. What is the Indian legal system? For Indian legal system, what is projected by this regime is Manu and Kautilya. What is Manu? Manu was never for constitution, never for democracy. It is highly discriminatory. It is based on caste discrimination, Varnashama Dharma, Chaturvarnya, and totally 200% it is misogynistic against women. It's such a system, and of course there is no legal system at all. Anyway, the system propagated by Manu is totally against our constitutional morality, and that constitutional morality is not some words written in the constitution. That morality, the origin of that morality and all the concept of the constitution is in our freedom movement. So this so-called Indianization, Bharatavalkar of our legal system meant absolutely a Manuvada interpretation and reintroduction of Manuvada. So now, dear friends, we have to fight three enemies simultaneously. One is this so-called Bharatavalkaran or Indianization of legal system propagated by the Sangha Parivar, saying that the entire Indian system, present system, is colonial. Second thing is that now, after this emergency, and of course, when we say about the present regime, there is no substantial amendment to the constitution made by this regime, except the case of Kashmir, Article 370. They don't want to amend the constitution, letter of the constitution. What they want is to create, to manufacture consent in the society, to polarize Indian society on religious and caste lines. When there is polarization of the society in terms of caste and religion, definitely do you know that it will benefit the majority of Hindutva force, not Hindus, Hindutva force, the political Hindutva force. And if such a threshold level polarization in the society, definitely there will be manufacturing of consent for amendment of the constitution to make the constitution a Hindutva constitution and non-secular constitution, a majority religious majoritarian constitution. So that is the purpose of this campaign. They knew something more, that whatever be the illegality and unconstitutionality in the laws made by the parliament, such as CA amendment, such as in Kashmir, Article 370, such as promulgation of anti-conversion laws, such as laws prohibiting or discouraging, criminalizing interreligious marriages. All these things, they know that whatever be the illegality or unconstitutionality, if it is challenged in the constitutional court may not be possible to dispose of its constitutionality in near future. And by that time, whether it would be set aside in future after some years, by that time, they can effectively polarize the society based on this discriminatory, non-secular, anti-secular, anti-social, anti-national acts. So that is the point. They can bring result even by executive orders, as they have as we visualize, we witness in Karnataka by way of dress code, hijab issue and all that. So this is the point. They don't want to amend the constitution as such. The purpose can be met by introducing such a discriminatory laws on religious lines, and that would give the required result of polarization of society. So how can we oppose this situation? That's a big issue. Because we just can't directly go to court and get result. So there lies the resolution of All India Lawyers Union to propagate our constitution, to bring the constitution to the people, near to people, to say about the constitutional rights, to explore, to explain to them how this bill or act passed by the parliament will affect those people, how far it is retrogressive, and to mobilize people from all sections of society. That's why we say that even lawyers' organizations are not sufficient to resist that. Our duty is something more. We lawyers should take the lead to mobilize people. We lawyers, law teachers, and law students should take the responsibility and duty to mobilize people without any sectarian restrictions on the issue of protecting our constitution and protecting democracy. For this purpose, we are sure that the basic requirement is that an independent, autonomous mechanism for selection of judges, because an independent, accountable judiciary is the cornerstone of our constitution and our democracy in the present context. That is why we say that unless and until we are able to bring about a totally independent, autonomous constitutional mechanism with a representation from all stakeholders of the judiciary for selection of judges of the constitutional courts, we shall sustain the present collegial system, making it more transparent and accountable. Only because it has got so many vices we have already projected and campaigned against. Still, when there is executive dominance, when there is clear campaign and attempt to violate independence of judiciary by the executive for dominance of executive, it is our duty and responsibility to resist that. Not that we are accepting this judiciary, accepting this collegial system as a perfect system at all. We have got criticism against it. We are not for that. We are not for the present collegial system. But till such an independent system is put in practice, it should be maintained. But of course, we have to strengthen it. We have to strengthen its transparency. That is our concept on this. Dear friends, on this Foundation Day, historically speaking, our presence is there on all these developments, positive developments in the Constitution. Our presence is there for expansion of rights under Article 21. Our presence is there in the judgment concerning right to privacy. Our presence is there, though not directly, in the matter of privacy issue and violation of our fundamental rights in the Aadhaar system. So, dear friends, the constitutional journey of All India Lawyers Union during the last 42 years is productive. Of course, there should be rectification of our mistake. We should be able to more effectively involved in all these matters, intervene in these matters, not only in terms of conducting cases, in terms of intervention in socio-political issues, educating the people, guiding the people, mobilizing the people. Still, we can proudly say during this period, our journey, constitutional journey, is productive. And definitely it reminds us our real responsibility in the present context to resist the onslaught on the constitution by the present regime, onslaught on democracy, onslaught on secularism, onslaught on our fundamental right, especially our right to freedom and expression. So, dear friends, definitely Andhra Pradesh committee deserves to be congratulated on this occasion. And on behalf of Central Committee, I congratulate the committee for organizing this function. With these words, let me conclude my intervention. Thank you. Thank you all.
We are very much thankful to Sri P.V. Surendranath ji, Senior Advocate, Supreme Court of India, National Secretary, All India Lawyers Union, National Committee. Now, I invite Sri Somnath Sharma. Somnath Sharma ji, are you there?
I'm here.
Yes, sir. Please address the occasion. Somnath Sharma.
I have listened to very informed intervention on the issue.
Yes, sir.
I have not much to add, except to remind our following of today that and leadership that when we found this organization 1982, we invited many people who were not connected with any left ideology, and they responded to our call.
Oh, 1 minute, Somnath ji, please on your video.
Yes.
Yeah, sir. Okay. Now, okay.
So we invited many people.
I'm happy to see my old friend Somnath.
Yes,
We were together at the time of foundation.
yes. When we did it, Nehru Yuva Kendra, I remember that people from all walks of life, in particular lawyers, who did not agree to our ideology, left ideology or a liberal ideology even, they responded to the call because the onslaught on the constitution was unprecedented. After return of the authors of emergency to power in 1980. So I would only request leadership of the states and the leadership, the central leadership, to approach every lawyer to join our ranks. Of course, with this one caveat that the persons with non-criminal credentials, they should not be admitted. Otherwise, everyone who want to work in the organization and some sense of working in a democratic organization, they should be approached. If we want to make all our claims turn into reality. With these words, I thank Andhra unit for giving me this opportunity to make this short intervention. Thank you very much.
Somnath Sharma ji is a former General Secretary of AILU National Committee. I thankful to Somji. And now I invite Anil Chauhan ji. Please give a message for 2 minutes. Anil Chauhan ji.
Mr. President and Secretary and the leader of the various states, first of all, I congratulate Andhra unit to hold such a program, and nice program at a very short time.
I want to see your face, sir.
I will charge money for that.
Vikas ji, God has no face.
Don't make him God. He's our beloved Anil ji. I will pay you, don't worry.
Sir,
But
sir,
Anil, but
then
Anil,
I am here, sir.
but Anil should aware that
Sir.
this Christianity, this naming him as a god means something very mischievous.
I agree with
Friends,
former General Secretary.
yes. Friends, we are facing the problem, or we can say the worst situation in which this organization was formed. Present situation is very bad, we can say, because there is continuous onslaught from the law minister, vice president, and even speaker of the Lok Sabha also. We should think that change all will be done by us, and despite our best efforts, we can say proudly that we are the only organization of the advocates which have all India character. We have regularly elections, we have regular membership, and this is the only organization. So my submission at this juncture, it will be that we should increase our membership. We should to approach the masses as a whole, because at present we are only 2.5% of the total advocates enrolled. So we should make it, certainly with the help of all others, we can do it. So with these words, I thanks AP unit again for holding such a program. Thank you, sir.
Yes, sir. I invite Sri Kodeshwara garu, Karnataka. Sri Venu garu, Telangana State Unit Secretariat member, Venu garu. E. Venu garu. Venugopal garu. Chennam Setti. Anybody from participants want to share anything? Anybody from the participants? From other states, I think. Yeah, Katavaru.
Okay, we are very thankful to the participants and the chief guests and Somnath Chatterjee and Vikas Ranjan Bhattacharya and all the advocates. It is very nice program for conducting this program. I am very thankful to the Andhra Pradesh committee and all the advocates. Thank you.
So any other speaker, or else we will close the session. Any other want to speak? Okay, friends, we are very much thankful to the speakers of this occasion, Sri Vikas Ranjan Bhattacharya, who readily accepted our invitation within short time. And more so, we planned it today morning itself. And Sri P.V. Surendranath, those two persons who are having a busy schedule, in spite of their busy schedule, they readily consented the invitation of All India Lawyers in Andhra Pradesh State Unit. And we thought that this is the right time to at least to memorize our some of our feelings since the inception of the organization, and leaders projected the same, and the values which are there in the constitution, we should preserve the same. And AILU is striving for the cause of social justice and equality and equal justice to all, and also preservation of rule of law and democracy in the country. So let us all hope that we will preserve these values by utilizing the tool of our organization to work among the people. And we are very much thankful to the Sundar Sharma and the other leaders who spoke here, and the participants also. We gave a very short notice after afternoon only. We placed the same in the WhatsApp groups. Anil Chauhan also, we are very much thankful to you, and other participants who participated from various states also, we are very much thankful. And this program was live casted by way of YouTube, and the link will be sent to all WhatsApp groups of advocates. Please utilize the same and forward the messages of our All India leaders to reach the same to the advocate community and general public also, for the better improvement of our organization in future also. The same will be placed in all groups of our AILU and advocate groups. We are very much thankful to you, and we are ending this session. Thank you very much, sir.
Thank you, thank you, thank you.